Good morning.
Good morning.
And welcome to the 2022 History Conference. My name is Mike Skip Weiler. This one says Mike Weiler, but there'll be a lot of people referring me as Skip. And I'm the current president of the Foundation for Restoration of St. Genevieve, and along with myself in the foundation, again, welcome. Couple of things. If you wouldn't mind, we're not using microphones today, so if you could move towards the front to listen, to be able to hear. Pardon me?
Why not? I have new hearing aids, so I'm okay, but that's been a problem.
I don't have an answer to that question. Okay. Also, a couple of other things. The restrooms, if you go out the door and just keep making lefts, you will find them. Also, if you wouldn't mind, please turn down or silence your cell phones if you haven't already. Before I leave, I'm going to share something with you. It's not much, but last week I was in town talking to somebody. I don't remember who I was talking to, but we were talking about, now which house? I said, yeah, this is the whatever house it was. And he goes, there's a lot of history around here. Yeah, I did exactly what you did. I go, yeah, yes, there is. And we're going to find out some more history, and that's what I like about it. There is a lot of history around here, and the more that we can soak up, the more that we can hear, to me, it just makes it so much better. So, again, thank you for coming. And Carl, one of our board directors, is going to introduce the first speaker. So thank you, and again, welcome.
Good morning. My name is Carl Kinski. I'm a member of the Foundation's board, and I'm pleased to introduce our first speaker, H. Riley Bock. He's an experienced attorney, was a public defender, a prosecuting attorney, the public administrator in New Madrid County. He was appointed to a 6-year term on the Missouri State Public Defender Commission in 2014 and currently chairs that commission. In addition to practicing law both as a prosecutor, public defender, and in private practice, Mr. Bock has taught at the New Madrid County Central High School and has owned and ran a farm. He's been active in a number of civic and nonprofit organizations, including the Higgerson School Historic Site in New Madrid. Mr. Bock is the past president of the State Historical Society of Missouri, 1995 to 1998, and has served as a trustee on the board there since 1984. So please welcome H. Riley Bock, who will present the New Madrid Earthquake Claims, a Disaster of Fraud. Thank you.
Well, good morning. I believe I will project enough where I don't need a microphone. I'm used to arguing to juries and keeping them awake. I'm your first hour of entertainment this morning. This particular subject came to my attention in the 1970s when I was researching an article on the Civil War involving New Madrid and the Dawson family. And I ran across a Supreme Court case titled LeSere v. Price. The case involved the earthquake land claim of a Dr. Robert D. Dawson, a prominent physician in New Madrid, politician, and a member of the commission that located Jefferson City. More about that case later. In 1978, I was a third-year law student at the University of Missouri in Columbia, trying to finish out my third year with a punt class called Legal History. I think I got 2 hours credit for that. A paper was required, so I decided to combine my interest in the New Madrid earthquake and do some legal research on the earthquake claims involving the case that I had run across earlier. In 1988, I turned that paper and research into this presentation. I made it at first to a small group in Sikeston, from Sikeston, a group of doctors one evening, and haven't given it since. So I had to kind of beef up on this to prepare it. But I think it's an interesting subject and kind of an odd twist to the New Madrid earthquakes. If you look back in December 1811, the national elections had set Congress in motion toward the declaration of war against England. As the prospects of war rumbled in the near future, another sort of upheaval, this one geographical in nature, was in the making in the country's newly acquired Louisiana territory. By that year, settlement of the best real estate bargain in history had just begun, with small communities being established along the western bank of the Mississippi River and several of its tributaries that arrived from the western wilds. About 2 a.m. on December 16, 1811, without warning, the first of a series of violent earthquakes struck. Centered in an area that is now the Missouri Boot Heel, the shocks were felt nearly 1,250 miles away. The shocks called church bells to ring in the nation's capital, residents to be shaken from their beds in Pittsburgh, the chimneys fall in Cincinnati. Residents felt the gyrations in Quebec, Canada. The quakes, which continued into 1812, were named after the nearest settlement to their center, the town of New Madrid. In fact, there was little left standing of the place after the last of the major shocks in February of 1812. Much has been written about the New Madrid earthquakes, and still is for that matter, by persons much more knowledgeable on that subject. Today, my talk picks up where most students of the event have stopped, but in my opinion, where the real tragedy of the event occurred, not in the lawless, sparsely settled, and then devastated frontier, but in the halls of Congress. It is from that place that came the disaster of public land fraud in the Missouri Territory that extended over 50 years. While the extent of the damage in the Missouri Boot Heel is still debated by scholars, all agree that the settlements of New Madrid and Little Prairie to the south, now Crothersville, were destroyed, and surrounding lands in Missouri, northern Arkansas, and western Tennessee were flooded to various degrees due to the sinking of land. There were early pleas for relief. Understandably, the nation was preoccupied with its war with England that was officially declared on June 18, 1812. Thus, no relief for the citizens of New Madrid District County. Yet, more than 2 years passed before the Missouri Territory Assembly passed a resolution asking Congress for some relief. The resolution duly noted that the recent aid Congress had sent to Caracas and asked that the same might be extended to its own citizens who were suffering in the worst of way from earthquakes. Does that sound familiar? We are a generous nation. The Assembly recommended that some provision be made for granting relief out of the public land or in some other way Congress may deem fit. Historically, it appears that this is where the mischief began. The scene drawn by the Territorial Assembly was a dire one. In fact, nothing was further from the truth. The settlements were being rebuilt, river commerce and trade had resumed, certainly some lands were damaged while others had been improved. So little of it had been cleared for production, the actual loss was quite small. Uncharacteristically, Congress did not send a delegation of their number, along with their wives and aides, on a fact-finding trip. If ever one was needed, it was then. Instead, Congress, ever so swiftly to act, did nothing. A year later, January 8, 1815, the Territorial Assembly sent another resolution directed to its congressional delegates, John T. Scott, who I understand was from St. Genevieve, to see that a law was passed for the relief of the earthquake sufferers. Scott did his job. 5 weeks later, February 17, 1815, the President signed into law an act for the relief of the inhabitants of the late county of New Madrid. Now, why it was late, I don't know. In the Missouri Territory, who suffered by earthquakes. I've always had trouble with this because all of the damage, according to the act, occurred west of the Mississippi. It ignores what occurred in Kentucky and Tennessee, and they, had delegates in Congress. So apparently they weren't concerned. So, the dividing line of damage. Indeed, this was a noble gesture by a generous government. At last, 3 years after the event, relief was finally on the way, or was it? Here's how it worked. Pioneer settler owns land in New Madrid County on November 10, 1812. That land was injured by a great earthquake. He is therefore authorized to locate on a like quantity of land owned by the United States within the territory. That's what it provided for. The mechanics of making a claim in the General Land Office in St. Louis were this. The recorder issued a location certificate to an applicant which allowed the applicant to locate on so many acres. The applicant then made his location. It would then be surveyed and platted by the surveyor, and the plat and location certificate were then recorded. The recorder would then present the location certificate to the survey to the General Land Office, this was in D.C., which would approve or disallow the location. If approved, the General Land Office issued a second certificate, and it was recorded. Now, here's the kicker. The bonus was for owners of lots, town lots, or tracts of less than 160 acres. They could exchange those small lots or tracts each for 160 acres. 4 city lots in New Madrid, which were then measured in arpents, 0.85 acres, less than 4 acres, could be turned into 640 acres of land, of good land. Unbelievable. The claimant need only swear that he owned property in New Madrid County, which in 1812 covered all of Arkansas and much of southern Missouri, to be granted a title to 160 acres in his name elsewhere in the Missouri Territory. Since land titles had to be recorded in St. Louis, scarcely any of the property owners in the town of New Madrid and Little Prairie, well over 100, had ever recorded anything of ownership. If the groundwork was ever laid for fraud, this was certainly it. Times being what they were, the residents of the devastated towns of New Madrid and Little Prairie, now rebuilt, were completely unaware that they were in need of this type of relief or that it was on the way. When news of the act reached St. Louis, land speculators wasted little time in packing their belongings, pens and paper, and heading for New Madrid. Almost overnight, the New Madrid area was inundated with these speculators who began purchasing land, lots, and tracts from unsuspecting residents. Townspeople were reportedly awakened from their beds to entertain offers to buy. Everyone was more than willing to sell lands that had fallen into the Mississippi River or sunk into surrounding swamps. Speculation in New Madrid certificates was widespread. Charges of misconduct were brought against William Rector, the deputy surveyor of Missouri and Illinois. Even the territorial governor, William Clark, could not resist the temptation to take advantage of the situation. Eventually, the residents of New Madrid and Little Prairie learned of the Relief Act and its terms. They continued to sell their damaged land to speculators. Tables were turned, and some speculators purchased tracts that had already been sold by area residents 5 or more times. Of course, not all lands were damaged by the earthquakes, but the Act made no provision for distinction and provided no definition. Because of the early land grabbing by speculators from the uninformed residents and their tainting of many of the certificates that were eventually issued by the fact that they were based on fraudulent title, many believe that the act never brought any relief or help to those to whom it was intended. The poorly drafted and hastily approved piece of land legislation, remember, once they decided to do something, it only took about 6 weeks to write it and sign it into law, could not have come at a worse time. The purchase of the Louisiana Territory, some of you will be familiar with this, its subdivision into territories and eventually states was wrought with land title problems. It was complicated and a confusing tangle. Conflicting laws and established priorities between Spanish land grants, French land grants, Indian treaties, military boundaries, territorial boundaries, and settlers' preemption rights. That is, if you settled on improved public lands, you could be the first to claim it. When a claim was finally allowed, resulted in a nearly impossible situation. Into this tangle, Congress sent the new Madrid Relief Law. The law is silent in dealing with other land laws and issues. It is silent as to what priority claims made under it would have. The litigation generated by this failure extended into the 1880s. One example of the problem is the right of preemption, which gave those already there the first right to purchase the land. In 1814, Congress extended the right of preemption to the Missouri Territory. Unfortunately, the already much settled area, which is now Howard County, was not then part of the Missouri Territory. Those residents, assuming they had preemption rights, were, to say the least, shocked in 1818 when the Secretary of the Treasury ruled that they did not. Immediately, holders of New Madrid location certificates, and there were plenty by then, began filing claims on the best improved farms and land in Howard County and in the flourishing villages of Franklin and Boonville. The reaction of those independent and frontier-hardened folks in Howard County was, understandably, violent. And there was hostility toward all strangers who appeared, whether or not they were speculators in New Madrid location certificates. Protests from the Missouri Territorial Legislature and the citizenry of Howard County caused the Secretary to quickly retreat. On January 21, 1819, he reversed his ruling, and on March 3rd, Congress extended preemption to Howard County. So you have preemption, then you don't have preemption, then you have preemption again. There's a time lapse, and of course, the certificates are filed in that time lapse. This creates an argument between the certificate owner and the real owner, the person entitled to preemption. This is what was going to be litigated. That the word in the act was so general in its terms, much administrative interpretation was necessary. A poorly worded law does not lend itself to helpful interpretation regulations. The New Madrid Act was no exception. Yet, the act, with all of its shortcomings and faults, placed in the hands of a competent administrator, might well have done some good. At least many of the problems written into its vague language could have been avoided by the proper exercise of regulatory authority of the General Land Office. Unfortunately, the man of the hour was Jonathan Meigs, Commissioner of the General Land Office in Washington. He would prove every way unequal to the task. The only land office in the Missouri Territory was in St. Louis under the competent direction of Recorder Frederick Bates. Bates would later serve as Missouri's second governor. Meigs, who expressed his doubts about the validity of the act from its inception and properly analyzed several of the problems with issuing and locating claims under the act, did nothing to avert the anticipated problems. Instead, on March 1st, 1850, he mailed a copy of the act to Bates in St. Louis and merely instructed Bates to begin taking applications. By August, Bates had come to understand many of the problems created by the act and refused to issue any certificates until he could receive some specific directions from Meigs. In addition, Edward Hempstead of St. Louis pointed out several problems with claim locations, their shapes, and whether or not they were to conform with sectional lines. Meigs issued a few directions, ignored the question about sectional lines, and the application process continued. Bates did his best. Since there was no record of most of the original landowners in New Madrid County, very few having ever recorded any title, Bates had no way of knowing if a claim was fraudulent or not. By January 17, he reported to Meigs that 324 cases of removal had been filed involving over 89,000 acres. New Madrid was about a half a mile square. William Rector, the deputy surveyor of Missouri and Illinois, would be in charge of conducting the survey requirements of the Act in order to locate a certificate. In June 1816, over a year after the Recorder's Office began issuing location certificates, Rector wrote to Meigs in Washington asking what public lands Meigs considered encompassed within the Act. The Act itself was silent. Rector also asked for directions of how to make the surveys and what locations would justify sending out a surveyor. Meigs' response demonstrated his unwillingness to give firm directions. The Act, he wrote to Rector in reply, is so worded that I find much difficulty in answering your questions and in reconciling the different parts of the Act with each other. Surveyor Rector designated by advertisement in September 1816 that certificates could be located on all government lands within 50 miles of either side of the Missouri River from St. Louis to Booneville. In a rare expression of his regulatory powers, Meigs directed Rector to decide by lot priorities of claims on the given land tract. I practiced law before all this magic stuff came along we've shown. But this is essentially the area, which includes parts of St. Genevieve County, that was designated as the area where you could locate on public lands. And there was a lot of public land here. And there were a lot of unrecorded titles and so forth. So, pretty big area, much larger than the city of New Madrid, of course. Meigs instructed Rector that the surveys were to be left to the discretion of the surveyor. A certificate holder could locate on any public land, whether or not surveyed for section lines, so long as it had been designated for sale by the government. In short, Meigs' instruction, or lack of them, authorized certificate locations on unsurveyed and unsectioned lands. Rector did just that. In June 1820, William Wirt, then Attorney General of the United States, issued an opinion questioning the validity of the location of every New Madrid land claim made previous to the running of section lines, since only surveyed lands were authorized to be sold by law. Wirt's opinion was 5 years too late. By 1820, hundreds of claims had been patented, settled, improved, subdivided, resold, and so forth. Commissioner Meigs seemed a little concerned with Wirt's opinion and the tragic results it would cause. In a great display of Meigs' passive incompetency, he accepted the ruling and ordered that all locations on unsurveyed lands, there weren't any, would have to be withdrawn. Surveyor William Rector saw at once the disorder of the ruling, if implemented, would cause. Appalled by Meigs' failure to understand, Rector correctly pointed out to Meigs that it was under Meigs' direction that the unsurveyed locations were allowed to begin with. He further argued that the Attorney General was wrong, since Congress was aware in 1815, when it passed the Act allowing for the relocations, that there were no sections or quarter sections surveyed in the Missouri Territory. Of course, Rector was right. Besides, he had no interest in having to resurvey every claim. The only body that could solve this problem was the one that first created it, Congress. And it did so 2 years later, in April 1822, when by law it perfected into grants those claims made before the date of the Act, regardless of their conformity to section lines. Along the way, Congress learned of the poor job it had done in 1815 with the New Madrid Act, and while it could not undo the harm already done, it did bring to an end the filing of claims. In April 18, it set January 1st, 1819 as the last date for obtaining a location certificate from the recorder. In all, 516 location certificates were issued and eventually located and allowed. In 1822, Congress set April 26, 1823 as the last day to actually locate a certificate. The location certificates gave the person the right to lay claim to untitled land. The ingenuity of speculators in attempting to make their claims more valuable caused many complaints. Claims were made on town villages and lots that had been set aside for schools and town commons. After all, these were public lands. One claimant filed a location on the alluvion formed by the recession of the Mississippi River between the city of St. Louis and the low water mark. Another claimed the village commons of Carondelet, a claim that generated a petition from the town's residents to the Territorial Assembly. Neither was eventually allowed. And while speculators were making their way around mid-Missouri attempting to locate their claims, the residents of New Madrid and Little Prairie stayed where they were, most never relinquishing any title on which the claims were based back to the United States. This situation was noticed early in 1817 by Alexander McNair, the first governor of the state. And he wrote Meigs that the former owners of New Madrid lands still occupy it. Further, he wrote, speculation may be attempted off the government to obtain the New Madrid lands at an undervalue. I submit, if the New Madrid lands were valuable, why did the owners need relief in the first place? McNair obviously failed to see the contradiction of his own statement. In 1820, Missouri achieved statehood, and following the compromise was admitted to the Union in 1821. Conflicts between claimants had up until that time, and handled through the General Land Office and by petition to Congress. The Missouri Supreme Court had barely found a place to sit when the first case involving a New Madrid claim came before it. The case would come at regular intervals for the next 60 years. The very first case, Stewart v. Rector, recognize the name, questioned the validity of a location certificate issued upon injured lands that had already been sold or surrendered for another certificate by those enterprising residents of New Madrid and Little Prairie who would not be denied their relief. The Missouri Supreme Court decided that these location certificates were just as valid as those issued where fraud was not involved, because only the United States was injured by the fraud, and it might never complain. The court wrote, it is a matter of doubt whether this certificate can ever be avoided in the hands of an innocent purchaser, being issued by a public officer on the government, to whose acts the people have a right to give credit or confidence. 2 years later, the same court decided just the opposite in the case of Hickman v. Gaw. When it disallowed a New Madrid claim, because the owner of the claim, an innocent purchaser, could not trace his title back to a legal owner of injured lands at the time of purchase. While there is no legal way to reconcile these two decisions, each was correctly decided because each worked to undercut an adverse fraudulent claim by a speculator against some innocent purchaser or landowner. In the first case, the loser, Mr. Stewart, sought to recover money damages from one of the individuals who appeared in his chain of title. The court found his title good and thus no damages. In the second case, the loser, Mr. Gaw, sought to throw Mr. Hickman off the land he had settled and improved in Howard County. Since Gaw and his predecessors had never had possession, they were in every sense speculators. The court continued to decide cases on equities rather than the law. The litigation peaked in the 1940s and 50s, probably due to the sharp increase in the state's population, which in turn led to a rise in the use and value of land. By far, the most important and celebrated case involving the New Madrid claim came before the Missouri Supreme Court in 1848 LeSere versus Price, the case that kind of got me interested in all this. Okay, go back. In March 1820, Congress granted the soon-to-be state of Missouri the right to locate 4 sections of land for the purpose of locating a seat of government. The grant was accepted, commissioners appointed, of which Dawson was one, and the site selected and reported back to the state's Constitutional Convention. Just before the Constitutional Convention confirmed the site, a Thomas Hempstead and A.L. Langham located a New Madrid certificate on the same site. This certificate location went undiscovered by the convention. The site was confirmed, and Jefferson City was located on the site. The certificate was issued on injured lands of a Jean-Baptiste Delisle. Delisle knew nothing of the location until 1842, nor had he ever consented to it. But the suit on the certificate was not brought by Delisle, but by the heirs of Dr. Robert D. Dawson. Dr. Dawson had purchased the Delisle land upon which the certificate was issued in September 1842. Dr. Dawson's heirs wished to perfect the location and surrender the Delisle lands to the United States just as the act provided. Dr. Robert D. Dawson had served as a physician, surgeon during the War of 1812 before coming west and settling in New Madrid. He was, as I mentioned before, one of the commissioners appointed by the Constitutional Convention to select the Jefferson City site. The property claimed under the Delisle patent was in the heart of Jefferson City. Upon it was situated the state's Capitol building, the Supreme Court, and many of the businesses and homes of the community. The home of one of the justices of the Missouri Supreme Court was on the disputed property, and he was disqualified from hearing the case. The stakes in this case were very high. If the Dawson heirs perfected title, then the state would have to pay them for the property, which, given its present state of development, was quite valuable. The highly publicized case was first tried in the Circuit Court of Cole County, Jefferson City, being its seat. A verdict was rendered in favor of the state. The Missouri Supreme Court decided the appeal in 1848. With 3 justices on the court, one being disqualified, the remaining 2 were split, one in favor of the claim of each side. The tie vote confirmed the decision of the Circuit Court. You can't get it overturned if you don't have a majority. The United States Supreme Court, that's where the case went next, in 1849 could do no better because of its makeup. Again, a tie decision of the Circuit Court trial was affirmed. They came so close. Further intrigue is added to the case when a year later, when Judge Scott, the justice who had disqualified himself in the case because his home was on the contested tract, wrote a decision in favor of New Madrid claim. In 1857, the Arkansas Supreme Court turned down the claim of the heirs of Surveyor Rector for the city of Hot Springs, Arkansas. In 1857, the Arkansas turned down the claim of Rector. Okay. While the New Madrid claim appeared in litigation for 40 more years, their impact in land speculation ended with the LeSere decision in 1848. In summation, perhaps it is not so much a surprise to any of us that such a young, inexperienced government could make such a mistake as it did in 1815 with the New Madrid Act. At the time of its passage, it was an unpopular act within and without government. Certainly there was no argument that it never accomplished its purpose. What it did do was make a few persons very wealthy and a lot of other people very miserable. Its impact in the Missouri Territory, the object of the government's bounty, was immediate and harsh. The act did as much to shake land titles in Missouri as the earthquake did to the land itself. The act makes a good example of the difficulties known and unknown in writing land laws. The fraud that swept the territory under the act was only limited by the willingness of the Missouri courts to create legal fictions and continually reverse their own decisions. To have done otherwise would have certainly made the courts a party to the fraud. But it is an ill wind that blows no one any good. The act lent a hand in speeding up the settlement of the mid-Missouri along the Missouri River. Nearly a fourth of the claims were located in Howard County. And this is a map of Howard County, and the black shows the New Madrid claims that were allowed.
Oh my gosh.
It's a good part of the county. It's all along the river. I mean, it's the good land. And then there's, of course, the claims that were disallowed and all the litigation. But this is one county, Howard County. And so it did. It actually did speed up settlement. And although this map says that the people who settled these claims were original claimants from New Madrid, they weren't. They had sold their city lots and so forth. But anyway, but to the survivors of the New Madrid earthquake, there was little relief save the humor release in A Hard Life in the Missouri Boot Heel had it selling some city slicker speculator a town lot 300 feet out of the Mississippi River for the 5th time. It will forever be difficult to understand how the United States Congress in 1815 declared the richest farmland in the world so valueless as to ask its owners to abandon it. Thank you.
So we have time for questions?
Sure, yes. Yes, sir.
This reminds me so much of what happened in French Peoria at the War of 1812, where a group of militiamen decided that the French Peorians were too close to the Potawatomi, burned and looted the town. The land claims and claims for compensation were filed before December in 1812, and finally the last case was adjudicated in 1867.
Yeah.
I mean, it was like listening to the same thing.
Yeah. When you made land law and did it poorly, you were going to create work for the courts. That was the only way. And most of these lawsuits, in fact, almost all of them, were between individuals. The government was not involved. Now, it was in the Laceer v. Price case because it involved government, the location of Missouri's government. But most of them were between individuals who were arguing over who had what, who had preemption and who had which certificate. And
That's exactly the situation in Peoria, where the French had preemption, but after the end of the war, English-speaking settlers came in and took over everything.
yeah,
Yeah, it was like listening to it.
yes, yes, ma'am.
Do you suppose John Scott knew what he was doing?
No, I really don't. Who drafted this thing? I mean, maybe he did, but it was a very short law. It didn't address. I mean, obviously these folks knew what was going on out here with land claims and the problems with surveying. I mean, there were, I guess, some of the meridian lines had been surveyed, but there were no sections or quarter sections. And if you look at the map of Howard County, if you could see those from the air, those 640 acre squares do not match the section lines. They're turned, a lot of them. They stand out very, very, because, that was where you take the surveyor out. Well, I want to start up here and go to here and go to here, and they weren't worried about section lines. So it created all sorts of, I guess if you drive across Howard County, and I lived there for a while, you end up making a lot of right turns. Or left turns, because the roads can't run the section lines because of these claims. Yes, ma'am. You had
Did you come across any claims for St. Genevieve?
I did not. Bob and I were talking about this last night. Although I guess there were some public lands available here. I mean, St. Genevieve had been settled for a good while. It was still a very large county. So, and the area, I don't, you go out west, there you may run into some, but I've never have seen a map of all, nobody's ever compiled a map of all of the claims. It would be interesting. There were 500 and some odd claims allowed. Yes?
There was one that I know of in Cape Girardeau County. It was actually Cape Girardeau and Perry County on Apple Creek.
Okay. I'm sure it's a good piece of land.
Not too bad.
Yeah. Yes.
Did any of these claims overlap with litigation going on over Spanish land grant claims and titles? Or do you...
I do not know. I don't recall reading a case that involved a Spanish land grant. There weren't that many of them. There were some in our area, and I'm sure some up here, where there were people settled during the Spanish administration, but there was hardly anybody out here in this part of the world. I mean, New Madrid County, or district, or whatever you call it, encompassed the entire state of Arkansas. I mean, which later becomes the Arkansas Territory when Missouri finally draws its state boundary lines. Up until then, it was New Madrid County, then it turned into Lawrence County, Missouri, not related to the Lawrence County over in West Missouri. And then when the Missouri state lines were finally drawn for statehood, it was turned into the Arkansas Territory. But in 1811, 1812, there probably weren't 200 people other than Native Americans living in Arkansas. So and I don't know if any of them ever sold their claims or their lands or not. I say Crothersville or Little Prairie in New Madrid are where the people lived, and they had the town lots, and of course that's what the speculators wanted. They wanted to take that less than 4-acre tract and turn it into a 640-acre location certificate. Owning land in the Missouri Territory at that time was like owning a penny stock. You had to have a lot of it in order to make money. You couldn't make money off 2 or 3 town lots, but you could make money off 640 acres if you could expand it into that, because the value would grow exponentially. But you have to have a lot of it to make, and that's why there were certain people that all they did was speculate in these things, and I'm sure some of them made quite a bit of money over the course, because as the court said, that the only person that's really hurt by these things are the federal government, and it might never complain. I don't think anybody was ever prosecuted for any of the fraud or anything else. It was all left to the civil courts to sort out and try to give the right person the land claim.
It was always interesting that at the same time all the Spanish and French land grants are being reviewed, and if you haven't seen the American state papers, there's 7 volumes of claims and how they ruled on those claims. Yeah. Some interesting reading, because it's St. Louis and St. Genevieve, New Madrid, right.
And they redrew all the claim lines in New Madrid to create the King's Highway. How they did this, I don't know, but those claims had a common line down what turned out to be the middle of King's Highway, Highway 61. And at some point, they pushed all those claims back to create that right of passage for the Spanish government. I don't know if they were the numbers remained the same, but I don't know that they were resurveyed. And as a result, every once in a while, you'll see a little patch of land along that line that's not where it's supposed to be. And it's with the wrong farm. And I think that probably is some of the remnants of that 200 and some odd years later, those lines were drawn. So interesting times, and certainly for trying to own land and establish yourself. But the New Madrid earthquake certainly did not help things. Any other questions? Well, thank you for inviting me up. I'm going to have to skip out. I've got to go to a Trail of Tears meeting in Cherokee, North Carolina. I've been on that board since the early 90s, and where we've been involved in establishing the National Historic Trail. It's been a very interesting event for me. I've certainly met a lot of interesting people, Native Americans and so forth. I incorporated the association back in about 93, and the signatures on the incorporation documents, besides myself, are Wilma Mankiller, who was then the principal chief of the Cherokee Nation in Oklahoma, and a fellow by the name of Jim Ed Taylor, who was the principal chief of the Eastern Band, the Koala Band in North Carolina. He later went to the penitentiary. Wilma Mankiller had a much more interesting career. But it's been, and I've met just all kinds of, there are all sorts of branches of these tribes scattered across the Southwest, Creek and Cherokee, Choctaw, and so forth. I met a lot of the chiefs and administrators of these tribes, and besides being involved with the development of the trail, we have well over 100 certified sites now, and they have just discovered the first removal fort location. Up until about 3 years ago, all of the removal fort locations had been destroyed or built over, and they finally found one that's in the middle of nowhere. And they've located the buildings and how it was shaped, and it's going to be kind of interesting to see how it develops in the National Park Service. And I know you all are dealing with the Park Service here, and sometimes it's a difficult undertaking. Eventually, it will turn out okay. Trust me, but it takes a while, and they're very slow and methodical, and sometimes very hard-headed. But eventually you get things done. So good luck on your national park. I think it's wonderful, and I say eventually it'll come to fruition for you. So thank you, and I bid you adieu.